This brings up another issue that I was just thinking about when I was talking. One of the things that we deal with a lot is the reason why people have a will is because they have assets. And a lot of people want to pass them on to different people. And, I've been in situations where people have set money aside for little Johnny, little Susie, and they're minors. So what happens if you leave money to a minor? Let's say grandma leaves a CD or a small life insurance policy to a 10-year-old. What happens in the state of Florida? Does that 10-year-old get that lump sum? Does it go through probate? What is the deal?
The 10-year-old doesn't get the lump sum. Someone is going, if it's not named, which is another reason to have a will, if you're going to leave money to a minor, you can name a person to be in charge of that money till they are 21. Someone will have to apply to be a conservator or a guardian of that child's money, and they'll have to file an annual report with the court showing where all the money goes, so if it's going towards the child's benefit. And then when that child turns 21, they'll be able to have the remainder. So
even if they have parents and so a grandparent leaves it to the grandchildren instead of the children, the parents have to go through that process?
They do. I've got a situation right now where I've got a client up in Massachusetts having to become the guardian or the conservator of his children's money because they were each left $50,000. And he's got to do it 3 times because he's got 3 children, and the courts won't let us release the money down here until that's done.
In Massachusetts, that's where my in-laws are from. I'm sure it's not free to do all that.
It's not free. I think it's $231 per child. So.
Grandma, what did you do? Grandma, please take some thought. So if you're listening out there and you want to leave something to your grandkids, make sure that you're understanding this. If they're under 18 in the state of Florida, right? 18? 21 in the state of Florida, they're not going to be able to get that. It's going to have to go through a process. So take a look at your beneficiaries. If you want to leave something to the grandkids, an easy way to do it, you can, is to put that in the will and name their parents or someone else that you trust as the guardian of that money until they turn 21. And then when they turn 21, well, then you're out of luck. I think let's talk about that a little bit. Let's say you don't trust these kids at 21. 21's the new 15, right?
That's true.
So now, can you do anything to prevent them from spending it all?
Sure. As part of your will, you can do something that's called a testamentary trust. It's basically setting up a trust in your will that'll take place when you pass away. And the children or the trustee, the person you name to take care of the money, will hold on to the money until the age you designate. So you could put age 25 and then the children wouldn't receive it until they're 25, or you could be creative and say, well, if they're 25 and have graduated college, or even more creative, they're going to get 25% at age 25, 25% at age 27, 25 at 30, and 25 at 34.
I love it. This is what is that, Great Expectations? Is that story with the So you would help people set this up?
Yes.
See, that's where it gets tricky, but that could be really what people want.
And that's why those online forms aren't always best, because once you start talking to a person, which a computer can't do yet, once they start talking to a person, you get to know what they really want to do, and you can tailor what they need in their will.